There are so many common misconceptions about separation and divorce. And so in this video, I would like to help clear up some of those misconceptions and provide you with some more information so that you can make informed decisions going forward. One of the most common misunderstandings or misconceptions about divorce is a misunderstanding about what separation and divorce actually means and whether or not they're the same thing. So separation and divorce are two separate matters. Separation is really a decision and action by you and your spouse to go your separate ways and to take steps to dissolve your relationship, whether it's a marriage-like relationship in a common law situation or a divorce. So a separation acts in many ways in law as a triggering event. And once you've separated, then what we do is we start looking at how we're going to craft your lives, you and your spouse's lives and the lives of your children going forward in this new reality as a separated couple. Divorce, on the other hand, is simply just the dissolution of a marriage. So the divorce often comes after a separation has occurred and after we have dealt with all of the issues arising from your separation, such as dealing with guardianship, child support, asset division, spousal support, etc., etc. Another common misconception that I hear from potential clients is that one is entitled to more financial support or more assets because their spouse had an affair. So in British Columbia and Canada at large, we have no fault divorce. So what that means is that regardless of whether or not your spouse had an affair, while it is certainly traumatic and may be the direct root cause of a separation, it really doesn't impact one's entitlement to property division, spousal support, child support, or the like. A third misconception that is common among many separating spouses is the belief, or in some instances a fear, particularly by fathers, that mothers will automatically get custody of the children. So that is not the reality in British Columbia, and nor is it the law. In British Columbia, our Family Law Act provides that if parents were living together with the child at the time of separation or during the child's life, then both of those parents are by default guardians of the child. And guardianship is made up of parenting responsibilities. So parenting responsibilities include things like the ability to make decisions for your child with respect to their education or religion, the right to get information about your child from third parties. So guardianship for most families who are separating generally is by default joint for both parents. Now, having said that, in British Columbia, there's also no presumption that the division or the allocation of parenting responsibilities goes either way. There's no presumption that parenting time should be divided equally or otherwise. So there's lots of issues around parenting arrangements, guardianship, parenting time with children that arise from your separation. As I've said, it is not the case that mothers automatically get custody. However, it's a really multifaceted area of law, and I encourage you to reach out to our firm should you have any questions on any of the misconceptions I discussed above, and we would be happy to help you. You can also find further information on all of the above issues on our website, and our website is listed below. Please reach out. Thank you.